Howdy, my name is Brian Foley. I am a criminal defense attorney. I'm the managing partner at Houston Criminal Defense Attorneys, PLLC. Today we're going to be discussing another crime related to DWI. It's called DWI with an open container. So what is a DWI with an open container? Well, it's pretty much the same as a regular DWI. The only time I've ever seen a DWI with open container charged is in the event that it's the first DWI that somebody's ever been arrested for. So if it's a DWI second or a DWI third, normally they don't worry about the open container, even if there is an open container in the vehicle. So what do we have here? Let's look at the law. It says that if it's shown on the trial of an offense under this section, meaning the DWI section, 4904 of the Penal Code, that at the time of the offense, the person operating the motor vehicle had an open container of alcohol in the person's immediate possession, then the offense is a Class B misdemeanor with a minimum term of confinement of 6 days in jail. Now, this is different. This is really why anybody would bother to charge someone with open container. What it does is it takes a regular DWI, Class B, and it increases the punishment range where the new minimum requirement for jail time is 6 days in jail. And so what you have to prove is that the alcohol is in the person's immediate possession, an open container of alcohol. So some of the common defenses that we have for this crime are, did the officer have the legal right to pull you over in the first place? Did he have reasonable suspicion that a traffic offense had occurred? Was there consent to search or question you, or did the officer violate some right that you have to privacy or to not be questioned? Did the officer coerce a statement from you or fail to read Miranda warnings after you were put into custody? Another thing for this particular crime is, was the alcohol container entirely empty? Okay, an open alcohol container has its own definition, and here's what it is. An open container means a bottle, can, or other receptacle that contains any amount of alcoholic beverage and that is open, that has been opened, that has a broken seal, or the contents of which are partially removed. So this would mean that, like a bottle of wine that still has the cork in it from its original, packaging, that would not be an open container. So you can drive a vehicle, with this alcohol that you purchase at the store, something like that, back home, not a problem. But if you open that bottle of wine and then bring it to a friend's house, technically that is a receptacle that has been opened and contains any amount of an alcoholic beverage, namely the wine. So what if the bottle is totally empty? What if you drank the whole bottle and it's left over? That is not an open container. It's a container, it's open, but if there's no alcohol left in it, it does not meet the definition of open container under 39031 of the Texas Penal Code. Another interesting thing about open containers is if that is the only ticket that you're being given, you're not being arrested for DWI, but you're just being given a ticket for having an open container, you cannot be arrested for open container. It's speeding, open container violations, and texting and driving. Those are the only three offenses where the officer may not choose to arrest you instead of just issuing you the citation. They have to issue the citation in those three cases. So how do we challenge these? We kind of talked about, the first step anytime you have a DWI case is we want to challenge the traffic stop, the reason that the police pulled you over in the first place. If we can successfully challenge the traffic stop, there's a doctrine called the fruit of the poisonous tree doctrine. And that doctrine is a legal doctrine that says any evidence that's obtained due to an illegal search has to be suppressed, or the judge is going to exclude that evidence from your trial. Well, if you win a suppression hearing and you get the evidence excluded, like of the blood test, of the answers to the questions of have you been drinking tonight, if all that information gets held out by the judge, well, then the prosecution doesn't have much of a case at all. They're really likely to dismiss the case. And so what is the punishment? Coming to the last section here, what is the punishment for a DWI open container? Well, it's a Class B misdemeanor. We talked about this at the beginning. The minimum punishment is increased from 72 hours in jail, which is normal for a regular DWI, up to 6 days as the minimum. But the maximum is 180 days in jail and up to a $2,000 fine. Now, you don't have to go to jail on a DWI. There's also probation. Even if everybody thinks that you're guilty of sin, you don't have to go to jail on a DWI. In fact, I would say it's pretty rare for somebody to go to jail on a DWI for their first offense. It would have to be a pretty extreme circumstance, maybe people being injured. But if they were injured severely, you wouldn't even be charged with DWI. You'd probably be charged with intoxication assault, which is a felony offense. So you'd have to have some strange circumstances, some pretty aggravating facts in order to get any kind of jail time on a first offense for DWI. But probably the worst part about DWI law in the last few years is that there's these things called state traffic fines. And the state traffic fine is if you are to plead guilty, you don't do probation, and they impose a jail sentence, maybe just not a jail sentence, but a fine only. Let's say we're able to negotiate a deal where all you have to do is pay maybe a $5,000 to $2,000 fine, or $500 to $2,000 fine, somewhere in there. And then the case is over. You can go about your life. You don't have any long-term repercussions other than just having the conviction on your record and whatever goes with that. Some people, especially people who are self-employed, would prefer to have a result like that. Well, we used to be able to do that without much consequence. Now you get hit with a $3,000 traffic fine. There are some exceptions to paying that for what's called indigency. So if you can't afford to pay for that after we consider your bills, your dependents, and things like that. But, if you're out here, you're trying to hire an attorney, and you're doing okay for yourself, they're probably not going to waive that $3,000. So whatever fine we're able to get, you can tack on an extra $3,000 of that. And it's all statutory. It can't be waived even by the prosecutor if they wanted to waive it. The only person who can waive it is the judge if they make a determination of indigency in your case. So that is the skinny on DWIs with open containers. One other point I wanted to make here. So we know what an open container is. It's anything that has alcohol in it. So how do you transport that opened bottle of wine that you opened with your girlfriend last night? You didn't finish it. You're going back over to her place and you want to bring it and finish the bottle tonight. Okay, here's how to do it. If you have a Tahoe or a Suburban, there's that luggage compartment all the way in the back. That is considered like the trunk of a car, and it's not going to be in your immediate possession, okay? Because for DWI with an open container, or for the open container law in general, it has to be in your possession. Another way is if it's in a cooler in the bed of your truck, that is not going to be in your immediate possession. It's okay to have open alcohol containers there. You just can't have them in the passenger compartment of the vehicle. And then again, when we're talking about Tahoes, SUVs, like Suburbans, things like that, even that interior passenger area, if it's the way back there behind the last row of seats, that is not going to be considered to be in that passenger area. It's okay to have it there. So that is the skinny on DWI with an open container. I hope you've learned something here. If you like what you've seen, like, subscribe, and hopefully we'll see you again next time for our next instructional video. Thanks.